case briefs, and so much more. LSData's got what you're looking for.
In 2010, a complex dispute between Traders Bank and Brett Dils captivated the Supreme Court of Appeals of West Virginia. The crux of the case was whether an individual could claim fraudulent inducement based on an oral promise, even if the promise was conspicuously absent from the written agreement between the parties. At the center of the lawsuit was a $2 million floor plan financing agreement that Dils had secured for a car dealership. When the dealership defaulted, Traders Bank required Brett's father, Sherman Dils, to sign a promissory note for $1,110,000, which was backed by several real estate parcels. The heated legal wrangle began after the Dils claimed that Traders Bank had conned Sherman into signing the note, using a vague verbal promise of reinstating the floor plan to the amount of $1.5 million. This, they asserted, never materialized. The lower courts grappled with the notion of whether the maker of such a promissory note could wield the defense and counterclaim of fraudulent inducement under these complex circumstances. They concluded that the maker did indeed have the legal standing to cry foul over fraudulent inducement. The court's rationale was that the individual who pens a promissory note can indeed assert a tort claim for fraudulent inducement. This would serve as a potent defense or counterclaim in any attempt by a lender to regain their outstanding debt. The stipulation was that the individual would have to demonstrate a financial reliance on the lender's oral promise, a promise the lender knew, or should have known, wouldn't be fulfilled. The milestone case was subsequently remanded to the Roane County Circuit Court for further proceedings. This case provided a potential precedent in evaluating the boundaries of fraudulent inducement, where verbal promises are at odds with written agreements.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class